Hi everyone, I just wanted to record a quick video. I know everyone's busy on the reason I'm voting yes tomorrow in the Voice referendum 2023. So, I mean, what we're talking about is a legal decision and it's based on an amendment to the Constitution, and I think the first place to go is to the actual proposed alteration. Obviously, there are some much bigger reasons for voting yes. But for me, one of the most important is that doing so will bring Indigenous Australians or Aboriginal and Torres Strait Islander peoples, our First Peoples, into the Constitution drafting process. Because remember, this provision was one that was drafted with the input, substantive input, from Aboriginal and Torres Strait Islander peoples, our First Peoples. And so what this constitutes is a retrospective inclusion of Aboriginal and Torres Strait Islander peoples into the drafting process of the Constitution, because importantly, there was no consultation or inclusion of Aboriginal or Torres Strait Islander peoples, the First Peoples, at the point of the constitutional debates or the drafting process that ensued. And so if we want now to remedy that defect, that omission, or that exclusion, our best opportunity is through this process of an amendment, where the actual amendment is substantively sourced in the Uluru Statement from the Heart, which was drafted by Indigenous peoples, Australian, Aboriginal and Torres Strait Islander peoples. So moving over to the text, you can see I'm talking to the actual bill. Here it's titled, "A Bill for an Act to Alter the Constitution to Recognise the First Peoples of Australia by Establishing an Aboriginal and Torres Strait Islander Voice." The Parliament of Australia, with the approval of the electors as required by the Constitution, enacts this bill. Now, tomorrow we are asked whether the Parliament should amend the Constitution on the terms set out in this bill. And you can see Schedule 1 is alteration of the Constitution. And it actually, as we know, or might not know, in terms of legal instruments, any alteration or amendment bill will include information about what exists currently and what should be inserted. So here it says, after Chapter 8, which is the chapter on how we alter the Constitution, insert a new chapter, Chapter 9, and its title will be Recognition of Aboriginal and Torres Strait Islander Peoples. And then after Chapter 8, insert Chapter 9, Recognition of Aboriginal and Torres Strait Islander Peoples. Okay, so this first item in the schedule relates to the contents page of the Constitution, and this second item in the schedule relates to the actual titles of the kind of headings and subheadings of the Constitution itself. And so after Chapter 8, insert, and then all of the following. So first we have the title, which I've just read. Then we have under Chapter 9, Section 129, titled Aboriginal and Torres Strait Islander Voice. Following that, it's not a division, but following that section title, we then have the substance of the section. And the first part you see doesn't have any enumeration, no numbers, but it says, in recognition of Aboriginal and Torres Strait Islander peoples as the First Peoples of Australia. Now, this aspect of the new amendment, or of the new section, is sometimes known as a chapeau, C-H-A-P-E-A-U, which is a French word for cap. And it's called that because it sits on top of the actual prescribed provisions of the section, like a cap does on the head of a French person. And some others have called it, in the context of this debate, a preambular statement, i.e. it's like a preamble to the actual substance, a statement that is preambular. Now, let's have a look at this chapeau or preambular statement. it says, again, in recognition of Aboriginal and Torres Strait Islander peoples as the first peoples of Australia. So that is the recognition component of the amendment. What it's doing is identifying a group of peoples, namely the Aboriginal and Torres Strait Islander peoples, and saying they are recognised as the first peoples of Australia. So I like to think that this chapeau has a kind of Venn diagram quality, or maybe a kind of X equals Y quality. And it simply states that a group we already identify as Aboriginal and Torres Strait Islander peoples in our general glossary are now recognised as the first peoples of Australia. Now, there has been debate, including in the Senate committee inquiry, as to the meaning of this provision in the legal sense. My submission to the Senate committee inquiry was that there is no relevant or unforeseen or unusual legal meaning that might arise from this chapeau, and that is based on the idea that at the end of the chapeau you have a colon, which conventional grammar says leads into what follows the colon. And so anything that this chapeau is said to do must be read textually by reference to what follows due to that grammatical mark that comes at the end of the clause. Okay? So the chapeau only does the recognition by reference to what follows, in my view. But even if you take a different view, I don't see anything other than this statement of recognition being one that has a common sense meaning of the X equals Y. Now, consequences of recognising Aboriginal and Torres Strait Islander peoples as first peoples are overwhelmingly, in fact, almost unexceptionally virtuous and beneficial. And I think, as some have said throughout this referendum lead up, it's simply stating a fact of history. And I think that the High Court and the community of Australian people as a whole are kind of smart enough and thoughtful enough to understand that statement as simply one of historical significance, and need not concern ourselves with, kind of far-fetched legal quandaries and dilemmas. And that's not just a statement of rounding it up. I think when I say that we are smart enough to understand it that way, I mean, I think the High Court is too. Now, carrying on, the first provision under Section 129, subsection Roman 1, states there shall be a body to be called the Aboriginal and Torres Strait Islander voice. Simple as that. This enables Parliament to create a body whose name will be the Aboriginal and Torres Strait Islander voice. Now, whether shall be is a requirement, conventionally, yes, there is a strong compulsion element when a statutory provision is drafted in these terms. And what that will mean is that a Parliament will be looking at this provision and they will say, well, it's almost like some non-human entity that commands this into being. There shall be a body. The non-human entity is really the Constitution itself. The Constitution, like some, divine being at the grand gates of some mystical place, says there shall be a body, something like out of Lord of the Rings, and it will thereby come into being. And so that's what the Constitution commands, as it were. And so therefore, there would be an ordinary and proper kind of observance of that command by the Parliament that there shall be a body. Now, of course, if the body were to cease to exist, arguments could be raised about whether or not Roman 1 operates to compel. But as it stands, I don't think anyone argues that we should already, before the amendment is even voted in, think about how we are going to get out of it. But in a sense, there shall be a body, so it will be. Now, Roman 2, the Aboriginal and Torres Strait Islander voice, okay, which picks up the language of Roman 1, and you can see it's all in capitals, so it's a proper noun, ATSIV, ATSIV. You could call it ATSIV. Now, the ATSIV may make representations to the Parliament and the Executive Government of the Commonwealth on matters relating to Aboriginal and Torres Strait Islander peoples. Okay, so we've effectively got a few different nouns at work here. The first is ATSIV, as I've said. It may make representations. That's the second noun. Representations are conventionally understood as oral or written communications that are not binding. And they are to be distinguished at the level of common sense and dictionary meaning from representation, singular, which might relate to legal representation. This is a plural, representations, which refers to the substantive communications that the body, ATSIV, may make. Now, it may make, it doesn't have to make, but it may make representations. It's effectively a power to make representations to the Parliament and the Executive Government of the Commonwealth. Okay? So those representations, those oral or written substantive communications may be made to the Parliament of the Commonwealth. So that would mean parliamentarians and their staff, potentially, and the Executive Government. That would mean officials, public servants who work in various departments of the government of the Commonwealth. So, for example, it could mean that a letter could be written to the Secretary of the Department of Social Security, or the Secretary of Services Australia, or the Secretary of the Department of Health, or the Minister of Health, or the Minister for Social Services. Okay? Now, those communications may be made, i.e. ATSIV may make representations to the Parliament and the Executive Government of the Commonwealth. Now, here it's narrowed in terms of their subject matter on matters relating to Aboriginal and Torres Strait Islander peoples. So what that means is that those substantive communications, which I'm calling as such but are named here as representations, are only validly made on matters relating to Aboriginal and Torres Strait Islander peoples. So matters relating to is a kind of connective part of the language here. But what are they connected? What are they relating to? Well, they're related to Aboriginal and Torres Strait Islander peoples. Okay, so things that are matters relating to Aboriginal and Torres Strait Islander peoples, that is a field. There must be a limit to the field, otherwise this language has no meaning. Where that limit lies or resides is a question for incremental discovery, but it is finite and there will be a limit. There is obviously things we can say about that, but it's important just to understand the mechanics of the provisions. And here we're just describing Aboriginal and Torres Strait Islander peoples. Now, I wouldn't say that that is a noun on its own that's of any concern to us here. The relevant noun is really this compound phrase, matters relating to Aboriginal and Torres Strait Islander peoples. Okay, that's the operative noun there. I'd say you've got a few. You've got ATSIV, may make representations to Parliament and the Executive Government of the Commonwealth on matters relating to Aboriginal and Torres Strait Islander peoples. They're really your four components of subsection Roman 2. So component 1, ATSIV, may make representations, component 2, to the Parliament and the Executive Government of the Commonwealth. Component 3, even though they're two things in component 3, on component 4, matters relating to Aboriginal and Torres Strait Islander peoples. Okay, so you're really putting together four things there. So that's important when it comes to subsection Roman 3. Now, subsection Roman 3 says, finally, the Parliament shall, comma, subject to this Constitution, comma, have power to make laws with respect to matters relating to the Aboriginal and Torres Strait Islander voice, or ATSIV, as we described, including its composition, functions, powers, and procedures. Okay? Now, before we analyse this final subsection, it might be worth just looking over what each of these subsections does as a matter of law. Subsection 1 says there shall be a body. As I said, that's commanding language that kind of has this implication of a constitutional command. Subsection 2, this is what I would call an empowering provision. It says that the voice may make representations, as we've already described. So you've kind of got a commanding subsection, then an empowering subsection. The commanding subsection speaks to Parliament in Roman 1. The empowering subsection in Roman 2 speaks really to ATSIV, to the voice. It says, you may do this, and it gives some conditions. Now 3, the Parliament shall. This is, again, the language of commandment. The Parliament shall. But it's an interesting one because it says the Parliament shall have power. It kind of combines the empowering and the commandment senses of the first 2 subsections. And it really designates or reposes or confers power to the Parliament of the Commonwealth. So each of the parliamentarians, ministers, cabinet, etc., will have power to make laws. So what this does is give power to Parliament to make laws on a particular subject matter. Now, most of Parliament's powers to make laws under the Constitution, and I'm talking about the Commonwealth Government, the Commonwealth Parliament, are housed under Section 51. But here is another one, separate to the Section 51 section of the Constitution, which appears at Section 129, subsection Roman 3, and says the Parliament shall have a power to make laws with respect to matters relating to ATSIV. Now, I'm aware that there is debate about the meaning of these provisions. My reading of this provision, which is consistent with many eminent legal minds, including 2 very recent former justices of the High Court, one Chief Justice, one former Justice, is that the Parliament's powers conferred under Section 3, even though they are not limited to these nouns here, composition, functions, powers and procedures, are limited to matters relating to ATSIV. So laws may be made with respect to matters relating to ATSIV. Okay, so this, in my strong view, this noun, this compound noun, matters relating to ATSIV, has to be distinguished from this compound noun, matters relating to Aboriginal and Torres Strait Islander peoples. The Parliament is not being given a power to make laws with respect to matters relating to Aboriginal and Torres Strait Islander peoples. It is being given a power to make laws with respect to matters relating to the Aboriginal and Torres Strait Islander voice. Now, there are several reasons to interpret it in the way that I have just then, but one is simply that there is a difference of language between this compound noun and this compound noun. And it's as clear as day because the last word is different in each phrase. One features the lowercase word peoples, notably, that picks up the language here. So this is a group of peoples, whereas this compound noun has the last word voice in capitals, which picks up the language here. And this compound noun refers to the body that was introduced in subsection Roman 1. And so, like there are limits, and there is a finite circle around the kinds of representations that may be made to the Parliament and the executive government by the voice, by ATSIV, so there is a limit to the powers to make laws conferred by subsection Roman 3. And that limit, that delineation, that circumscription is defined by this compound noun. which speaks and echoes and calls back to the same compound noun introduced here. So in my view, the Parliament would not be able to make laws under this new power, under section 129, subsection Roman 3, with respect to matters not relating to the Aboriginal and Torres Strait Islander voice. And it's a simple binary argument. It is either relating to the Aboriginal Torres Strait Islander voice or it is not, in my view. And there must be a line that distinguishes that binary. Maybe that line is already informed by some of the examples given in the following phrase: composition, functions, powers, and procedures. These things have to be determined by reference to the common law and how statutory interpretation unfolds. But one of the interesting points of law about this amendment is that it is a new section, and so some of the existing common law that relates to parliamentary powers conferred under the placeta, the subsections, under section 51 of the Constitution, will not be simply applicable to this new subsection, because the common law relating to the section 51 heads of power is not directed to the way a court will interpret the textual conferral of power with respect to the voice under this new subsection. And so arguments that are made on the footing that past decisions of the High Court relating to, for example, the way in which the external affairs power has been used to enable Parliament to make laws about treaties and conventions, aren't necessarily straightforwardly superimposable onto this new power under section 129. Now, I'm not suggesting that those things aren't of relevance and might not, through argument, be superimposed in a way. But I don't think that the doctrine of precedent, stare decisis, translates to a proposition that common law with reference to section 51 becomes common law applicable to section 129. And so for that reason, I think it's important to look at this new section as a new section and read the text very carefully, as I have, with respect to distinguishing between nouns and looking at the way in which different verbs operate and how nouns such as these, composition, functions, powers, and procedures, might inform a reading of the provision with respect to parliamentary intention. And all of these things should impact on the way in which we understand section 129 to operate. Now, having read this provision as I have today and in the past, I think it is very well written. I think it is very well conceived. I think it is safe. I think it is virtuous. I think it is credible. I think it is based in careful drafting, and I think it has been stress tested. I think it is, in substance, beyond the legalistic issues. It represents a critical advancement in terms of Australia's compliance with its international law obligations under, for example, the United Nations Conventions on the Rights of Indigenous Peoples. And for the reasons I provided at the start of the video relating to the fact that no wording authored by Indigenous peoples has ever found its way into the Constitution before, I think that this wording, which has been partly authored through a process of consultation and translation by Aboriginal and Torres Strait Islander peoples, resolves this historical exclusion, this historical defect. And for that reasons, I would urge, Australians of good faith and of goodwill to vote yes tomorrow. Thanks.